Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you. This is the March term, the beginning of the March term of the Court of Criminal Appeals in the Western Section, which meets in Jackson. On the panel today, to my right will be Judge Tim Easter from Williamson County, and to my left will be Judge Ross Dyer from Shelby County. And I am Kerwood Witt, and I come from Monroe County in East Tennessee. Arguments today will be 20 minutes aside. If the appellant wishes to reserve a portion of that 20 minutes for rebuttal, then counsel should make that announcement at the beginning of your argument. Call the case, please.
Dontel Morgan versus State of Tennessee.
Good morning. May it please the court. My name is Lance Chisholm from Shelby County, represent the petitioner Dontel Morgan. At this time, I would request 2 minutes of rebuttal time. The 5 issues that I would like to try to raise today are that counsel was ineffective for failing to file and litigate a motion to suppress. Counsel was ineffective also for failing to subpoena the victim's medical records so the court could review those in camera. Counsel was ineffective for failing to adequately investigate the case. The guilty plea was not entered knowingly, intelligently, and voluntarily. And finally, we contend that the post-conviction court erred by denying us funding for an for an investigator in this post-conviction. Just a brief summary of what this case was about. This was a guilty plea. Mr. Morgan was indicted on numerous different charges. One set of charges, he had about 7 counts, was against victim LH, and that included very serious charges such as aggravated sexual battery, aggravated robbery, employing a firearm. So that was one indictment against LH, and I'm using the initials to maintain the privacy of the victims. The other indictment, there was the serious charge, was against AB. And this one, you had attempted rape, aggravated robbery, employing a firearm, very serious charges again. He was also indicted on about 3 different aggravated burglaries and then 3 failure to appears. So he ended up pleading guilty in a package deal to 20 years total, 18 at 100% on the serious cases and 2 at 30% on the aggravated burglary. So it was 20-year total sentence. So the first issue was counsel ineffective in failing to try to suppress the victims in court and out of court identification. So
before you get too far into this, let me just ask this question. Did I read your brief correctly in that you're only attacking the plea in case number 14-03630, which involve LH and AB? That's the only plea you're attacking.
Well, Your Honor, we're saying that the whole agreement should be set aside because the ineffectiveness in those serious cases, if counsel would have done what we're saying he should have done, then there never would have been a deal. So yeah, I mean, we're attacking all of the case numbers, the whole plea. You're saying
your argument is if you're successful on this petition, then all 8 of these cases are set aside.
Correct, Your Honor. That's the argument we're making.
Can you attack more than one case with one petition for post-conviction relief?
That was my understanding that, if the ineffectiveness if he was ineffective in two of the major cases that were a big part of this plea, that, you know, we should be able to attack the whole plea and set aside all of the convictions, because these were the major cases driving this guilty plea, the ones he was ineffective, the cases he was ineffective in. So, yes, Your Honor, I would submit you can't attack them all because it was one plea with multiple case numbers. That's my understanding of the law, that you can attack a single guilty plea even though it has multiple indictments. If I'm wrong about that, then, you know, obviously I'll stand corrected, but that's been my understanding for a number of years. So again, the photo identification was a key issue in the two serious cases, the ones that really got the most time on.
Mr. Chisholm,
and, you know, the law says,
Mr. Chisholm, in reading your brief, you know, it's clear he didn't file the motion to suppress, but the law is pretty clear. You have to show not only did he not file it, but that you would have been successful on it. And I'm not sure from reading your brief that you've proven, and maybe the record will bear it out a little bit better, but in reading your argument and reading your brief, that you've proven you would have been successful if he'd filed the motion to suppress. I mean, that's your burden.
Well,
in
Your
order to
Honor,
get the PC relief you're looking for.
Well, Your Honor, one, I will concede that it would have been better for us had we been able to put the victims on at this post-conviction, you know, because when you're attacking an identification, photo spread, it's very helpful if you have the victims to ask them, you know, about the procedure. Was it suggestive or not? And that's I'm going to kind of skip ahead to my last argument now. That's why we needed the funding for the investigator, because I tried my best to find these victims, and I couldn't find them through looking on the internet and knocking on doors and stuff like that. So, you know, Tennessee, we don't give funding on non-capital post-convictions. The case law says it does not violate due process. But I contend that it does violate due process to require a petitioner to show prejudice and present these witnesses, but not to give us the tools we need to get them into court.
Well, let's go ahead and jump to that real quick, because since that, I agree with you, 90% of your argument centers on your last issue. I mean, our Supreme Court's made it pretty clear that this isn't a due process issue. So, you know, there's really not much this court can do, even if I agree with you that you should be given expert funds. You know, there's not much we can do. I mean, I recognize you're going, you know, you're kind of going down the ladder, but you know, even if you'd had an expert, I mean, a investigator, you know, there's still no proof that even if you'd had an investigator, you'd have found these victims. I just don't know how you get there without the victims based on the record we have, at least for this issue. Now, maybe for the other issues, you know, you can show that expert or investigator funds, but you can't show that these people would have ever been found even with an investigator. And that's your burden.
Right, and I will say, and I think I made this clear in the lower court too. The family in this case had pulled together some limited funding for an investigator. I think it was maybe $250, I can't remember the exact amount, but the investigator had no luck with the very limited funding we got, and then I was unsuccessful too. But you know, post-conviction law talks about all you're really entitled to is an opportunity for a meaningful hearing. Okay, and my position is you really don't have that opportunity if you're not given the funds you need, you know, to get the investigator, to get the experts. And I know this court can't overrule Supreme Court precedent. I'm just basically raising this to preserve it for, you know, down the road. But going back to this case, to address your question on these witnesses, I would respectfully submit that even though we did not present them, we presented enough of a record where this court can determine that this was an unduly suggestive photo spread. And the reason it was, it's a 6-person photo spread, 3 people on the top, 3 on the bottom. And the date of the photo spread is actually listed right under petitioner's photo. He's in the lower right-hand corner, position 6. And it says printed on whatever date, March or June 30th, 2014, 12:11 p.m. So it's our position that the victims, upon looking at that, their eye would have been drawn toward, the dates right under his photograph, and they would have thought, well, they just put his picture in here at 12:11 p.m. This must be the perpetrator, because, they just must have put his picture in here. This is the one that did the crime. So that's that's unduly suggestive, is our position. The next question is, was the identification nevertheless reliable? Under the Biggers test, you look at, if it is unduly suggestive, you still look at the identification. Was it reliable? And that's where you look at things like the opportunity to view the perpetrator, degree of attention, all of these Biggers factors. And the record, I introduced the 911 call where LH talks about she saw the perpetrator for just a little bit and that he was very, really tall. But Mr. Morgan, the petitioner's 5'6", 145 to 150 pounds. So, her identification is questionable there. And she even concedes saw him for just a little bit. And she also said he had a covering on his mouth area, a mask of some sort, a cloth mask, and had a golf hat on. So I know the state's arguing that with a mask on, you can still see, the rest of the head. But when you have a hat on too and a mask, I think that does change things. And so, in her statement to police, she did say he was 5'9", but the fact that she said he was, tall in that 911 call really raises serious questions. In my opinion, I would submit that that's not a reliable identification. She was under a very stressful event. Her baby was in her arms. She was being sexually assaulted at gunpoint, which is another factor. With cases talk about, there's this body of law or science out there that victims sometimes focus more on the gun than they do the perpetrator's face. So you take the excitement of the event, the facial coverings, her descriptions, and I would just submit that we have proven her identification was tainted by this unduly suggestive photo spread. Now, as to the other victim in the other case, AB, she described the perpetrator as being 5'10", 5'11", 185 pounds. Again, Mr. Morgan's 5'6", about 145 pounds. She said the perpetrator was wearing a skull cap. I think that could throw off a person's identification when someone has headgear on like that. And it was a very 4-minute attack, a very stressful event. I would submit it'd be hard to really study the perpetrator's face in a situation like that. So I would submit, based on the record, we've established it was ineffective not to raise this claim. Counsel said he just never noticed the date of the photo spread listed under the petitioner's photograph. So this isn't, the law says attorneys should file motions to suppress if there are arguable grounds to file it. And you are allowed to make a strategic decision not to file a motion to suppress. That Nicholson case says that too. But in this case, I would submit it wasn't strategic because counsel simply missed the issue. He said he never even noticed that date of the photo spread being under the petitioner's photograph. So, you can't say it's strategic if you never saw the issue in the first place. And it's our position, had counsel won this suppression hearing, the petitioner would not have pled guilty. In fact, he testified that if counsel would have just filed the motion, he would have gone to trial because he would have felt that counsel was fighting for him. So if he would have won the motion to suppress, certainly petitioner would not have gone to trial. I mean, this case really was based on the victim's identification, especially the one against LH. That's all they had. No fingerprints, no DNA. It's just her identification of him, and because the mother could not identify the perpetrator. It would have resulted, there's a reasonable probability he would not have pled guilty had this been suppressed, the identification. As to AB, it was mostly her testimony. There were no prints or DNA. Now, there was one piece of other evidence I must concede. They found the defendant's cell phone at the scene of the crime with his picture on the home screen. And the state makes a big argument about that that shows that they still had proof against the petitioner. But, they could have gotten around that. The defense could have said, that the perpetrator somehow had petitioner's cell phone, or maybe the petitioner dropped his cell phone there when he was in the area. I mean, there are ways you can get around and deal with that evidence. If you can suppress her identification of him, you're in a much better position. And like I said earlier, if you beat these two serious cases, that really changed the whole complexion of the negotiation process, because the other charges were just simple C felony, aggravated burglaries, failure to appear. Probably could have worked out some kind of probation here in Shelby County. Those type of cases get worked out a lot, some kind of probation, 3 to 6 years. He was range 2, but some, they will go lower. Like I said, you have to beat those serious cases, the real, the ones against AB and LH, to change the complexion. And counsel could have done that if he would have suppressed these identifications. The next issue is about the victim's medical records. It's my position that the counsel needed to get AB's records to see if she was intoxicated that night, to see if she gave a description that was different from what she gave police. It's just a good investigative strategy to try to get the victim's records and subpoena them to the trial court for the court to look at. Counsel said he never did it. It never occurred to him to do that. So he never made a strategic decision not to do it. He just didn't do it.
Did the PC court look at the medical records?
She did, Your Honor, and she said there was nothing in there exculpatory. And I'm just asking this court to review those records, those sealed records, just to double check and see if that's indeed accurate. See if there is anything exculpatory in those records. I know I'm not allowed to look at them, but I provided them for the court to look at, and hopefully there is something exculpatory, and I would ask the court to look at those. Failure to investigate. Counsel said he didn't really interview the victims because the case never got set for trial, basically, was his rationale. And he had their statements to police. But it's our position that even though you have the statements to police, you still need to do an independent interview of the victims to see what they have to say. You never know how that interview went with the police, if there was something suggestive going on or what. You just need to go interview the victims yourself, and you need to do it before you don't have to set a case for trial before you go investigate. In fact, you should do it before you decide to set it for trial or not, to see if you need to set it for trial. He could have interviewed the victims. They may have said something that really helped him that he could have used in the negotiation process. So you don't wait for a case to get set for trial before you start interviewing victims. You want to do that early on, and he failed to do that. Of course, we failed to show prejudice because we did not present these victims at the post-conviction hearing, but that just takes us back to my other issue. I've already discussed that, being denied the funding really hurts post-conviction petitioners here in Tennessee. And then the last issue is basically that the guilty plea was not entered knowingly, intelligently, and voluntarily. It wasn't knowingly entered because he did not know the results of the investigation or the motion to suppress or the victim's medical records. And so that's why it wasn't knowingly entered, because he pled before knowing what would have happened, because counsel never did these other things that we've been talking about. And you can tell in the plea the petitioner is pretty uncomfortable. He says at one point, "I'm just not comfortable doing this." And the court presses him a little further. He's like, "Okay, I'm going to do it, And but like I said, if you read that guilty plea transcript, you can tell he's really having some hesitation. And he says counsel never saw him one time the whole time in the jail. And I subpoenaed the jail record custodian. She said, "Yeah, no record of counsel visiting this inmate in the jail." And counsel said he cannot remember visiting him, but he thinks he's sure he would have done it, but he has no memory of it. So, petitioner, I would submit, just pled guilty because he felt, and this is what he said, he felt like he had no choice. Counsel wasn't working for him. He didn't want to try to go to trial with a counsel who wasn't putting any effort in the case, and he didn't want to end up getting a life sentence by going to trial with this counsel who was putting no effort into his case.
You're getting into reserved time, Mr. Chisholm.
Thank you, Your Honors. And so I would just ask the court to remand the case for a new trial and, set aside the guilty pleas. And thank you very much.
Thank you. Ms. Decker.
May it please the court, Catherine Decker representing the state of Tennessee. The petitioner is not entitled to relief on any of his claims. And because he's basically complaining about his global plea, I think it bears repeating, although defense counsel's touched on some of the backdrop, I think it bears repeating to just have the backdrop of the plea in mind. At the time he pleaded guilty, the petitioner was facing possible convictions in 8 separate indictments, a total of 24 counts, and he was facing a possible effective life sentence. The convictions for the first 6 indictments were assured. The first 3 indictments concerned aggravated burglaries. The petitioner had confessed to all 3 of those aggravated burglaries. So his convictions for those 3 indictments was assured. His indictments for the next 3 indictments concerned failure to appear related to hearings on those aggravated burglaries. And so the failure to appear was indisputable. For those 6 indictments, the petitioner faced a total of 63 years in prison. The 7th and 8th indictments concerned the aggravated robberies of Ms. Holt and Ms. Bass. For each of those 2, he faced an additional 30 years in prison. And significantly, as has been touched on, petitioner's cell phone was found at the scene of the aggravated robbery of Ms. Bass.
Ms. Decker, to go back to Judge Easter's question that he asked Mr. Chisholm, in reading the briefs, it really looks like Mr. Chisholm is only challenging the last indictments 7 and 8, as you just described them. And he's not really challenging the first 6 indictments. I guess the question is twofold. To Judge Easter's original question, can he just file one PC that attacks this 1 or 2 charges, 2 indictments, and does that undo everything, or does it just undo this?
My understanding is because this was a global plea, that it would undo the entire global plea.
Even though he has no problem, so to speak, with any of the other cases, this does everything, so he's back at looking at an effective life sentence in 24 counts.
Absolutely. But I also think that his last issue, when he says his plea in general was involuntary, I think that would encompass the entire global plea. But even this was a global plea, and so I think that even attacking the 7th and 8th indictment would undo the entire thing.
Thank you.
So as petitioner was facing these convictions and a possible life sentence if he proceeded to trial, his trial attorney was able to negotiate a global plea of 20 years. And so now, nevertheless, he claims his trial counsel was ineffective. Now I'll turn to the specific issues. So the first issue is whether counsel was ineffective for failing to file a motion to suppress Ms. Holt's and Ms. Bass's photo identification. He was not ineffective for 2 reasons. First, the petitioner hasn't established that counsel was deficient for failing to file the motion to suppress. There was a reasonable and strategic reason for him not to file the motion to suppress, and that is that at the PC hearing, counsel testified that he recalled the prosecutor saying that the global plea would be affected if the counsel started to file pretrial motions. Essentially, according to the trial counsel, the prosecutor told him that if he wanted to file piecemeal motions, that he just needed to go ahead and set these cases for trial. So filing these piecemeal motions would have jeopardized the entire global plea. And it was certainly reasonable for counsel not to file piecemeal motions, especially since they would just concern the 7th and 8th indictment, when it would jeopardize the global plea for the remaining indictments, for which, as I said, he was surely would have been convicted, and for which he was subject to 63 years in prison. That was a reasonable decision. Whether counsel made the strategic decision specifically as to the motion to suppress, as defense counsel has argued, is not dispositive so much as the council deciding not to generally file piecemeal motions prior to trial after the prosecutor had indicated that doing so, any piecemeal motions would jeopardize the global plea offer. And certainly, counsel's not deficient for failing to do something that highly benefited his client. But furthermore, the petitioner has not established that he suffered prejudice by counsel failing to file the motions to suppress. And I just want to address something, and I think Judge Dyer mentioned the normal standard here, which is that petitioner has to establish that if counsel had filed these motions to suppress, he would have been successful on the motions, and that's required to establish prejudice. That is the standard that still should be used here, although petitioner testified at the PC hearing that the result of the motions to suppress was, it wouldn't have mattered. He just wanted counsel to file anything, and even if he had not been successful, he would have proceeded to trial. That is incredible. And the PC court was entitled to find that testimony to be incredible. It certainly was incredible. And by denying this, the prejudice prong of this claim, as the PC court did, the PC court has implicitly found that claim to be incredible. And so we really have to look at whether at the normal prejudice standard, which is, would the motion to suppress have been successful? And it would not have been successful in this case because, first of all, the photo lineup was not unduly suggestive. First of all, and I think defense counsel has stated what the issue is, and that is that on the photo lineup, underneath the petitioner's photo on the bottom right-hand corner are printed the date and time stamp, Monday, June 30th, 2014, 12:11 p.m. It's not unduly suggestive because, first, if you look at that, it's particularly small font. It really doesn't stand out at all. It's particularly small font. And some of the copies I've seen, the ink was particularly light as well. Maybe I'm not sure how it appeared to the victims, but that's how it appeared on some of the copies I've seen. So it's not even clear that Ms. Holt or Ms. Bass would have even noticed that. Counsel said he didn't even notice it. It's really not very noticeable. But more importantly, even if they had noticed this time and date stamp, the time and date stamp has a significance of its own. And that is, this is the June 30th is the date that the victims were brought to the police department and shown this photo lineup. So to them, this time and date stamp would have reasonably indicated nothing more than some administrative significance that was just completely unrelated to who, I don't know if you can hear the siren, I'm sorry, I apologize. Completely unrelated to who the perpetrator of the offenses were. And it certainly wouldn't have signaled that they should have chosen any particular photograph. It was merely a date and time stamp that they would have recognized as the date that they were brought to the police department. So it was not unduly suggestive, but even if it were unduly suggestive, even if the victims had noticed the time and date stamp and their eyes had been drawn there and they had thought that meant they were supposed to pick the defendant, which it's just not plausible. The bigger factors weigh in favor of rejecting this claim. Ms. Holt had ample opportunity to view the petitioner. The petitioner climbed through her apartment window when she was in the living room. So I think she saw him climbing through the window. She saw him long enough for him to enter the living room, steal some items from her in the living room, direct her to the bedroom, demand money in the bedroom, go through her dresser, take additional items, and fondle her and her mother. She also saw him in the light of her bedroom. She was face to face with him. He was close enough to rub her between her legs and to pull up her dress and rub her vagina with his fingers. That's how close he was to her. He did have, she said, a piece of cloth on the lower part on his mouth and a hat, although we don't know how far down his forehead the hat came. And she did say that she saw him a little bit. She said that to the 911 operator, but that does not mean that what bit she saw of him was inadequate for her to identify him. He was face to face in the light of the bedroom for that length of time I had just described. And although defense counsel says that it was a highly stressful situation, so she wouldn't have paid attention, I would completely disagree and say because it was such a highly stressful situation, she was paying particular attention to him. She had an infant with her, a 4-month-old infant. And so, of course, she would have paid a high degree of attention to the man that came into the living room while she was, potentially threatened her infant, and then actually sexually assaulted her and threatened to sexually assault her mother. On the fourth Biggers factor, the description that she gave of the height of the defendant is just not significant. Whether a woman can accurately assess a man's height and weight is just legally insignificant. And the difference in height relates not at all to any of the defendant's facial features. Finally, she was competent enough to write. This guy was the one who robbed and sexually assaulted me. And she identified him only 9 days after the assault. And this court has upheld identifications 9 days after the assault. As for Ms. Bass, she saw the petitioner for 4 minutes, a significant amount of time. He was in a lit stairway in her apartment complex. Again, they were face to face. He was close enough to kick her, to hit her, and to attempt to rip her shirt off. Of course, all of her attention would have been focused on this person who was face to face with her, trying to rip her shirt off. She was mainly accurate about her description of him. Again, she did not accurately assess his height, and that's just not legally significant, especially given all of the other Biggers factors. She was confident enough to write, "This is the guy who attacked me," on the photo lineup, and she identified him only 2 days after the attack. The petitioner would not have prevailed on a motion to suppress the photo IDs, and for that reason, the PC court properly denied this claim, and this court should do so as well. So unless you have any further questions on that issue, I'll turn to the next issue. Concerning issue number 2, whether the PC counsel was ineffective for failing to subpoena Ms. Bass's medical records, he certainly, first of all, was not deficient in failing to do so. He had no reason whatsoever to suspect that Ms. Bass was intoxicated, as defense counsel has suggested. He had no reason to do that. This would have been purely a speculative fishing expedition, and counsel is not deficient for failing to engage in a purely speculative fishing expedition. And as this court will, I assume, likely discern, just like the PC court did, there was nothing exculpatory in her records. And so petitioner has not established that he was harmed in any way by failing to, for his counsel failing to petition those records. Unless there are further questions on that issue, I'm going to defer to my brief on issues 3 and 4 because they're so readily disposed of by established case law. Issue number 3, because as defense counsel concedes because he did not bring Ms. Holt and Ms. Bass to the PC hearing, he can't establish that he was prejudiced, and that's under the Black case. And issue number 4, as Judge Dyer has correctly pointed out, the Tennessee Supreme Court has ruled against defense counsel's position in this, and this court's bound to follow that. So as the law stands right now, he cannot succeed on that issue. So turning to issue number 5, whether the plea was entered knowingly, intelligently, and voluntarily, absolutely, the PC court properly held that it was. This court looks to the plea colloquy and to the Blankenship factors to determine whether a plea was entered knowingly, intelligently, and voluntarily. During the plea colloquy, the petitioner informed the trial court that counsel reviewed all of the plea papers with him. He understood his plea. He understood his right not to plead guilty. He understood the rights he was giving up. He stipulated to the facts. They were all presented during the plea hearing. He stipulated to those facts. He testified that he understood his charges that he was pleading guilty to. He informed the trial court that he understood his potential punishment. He was asked whether he wanted to plead guilty or proceed to trial, and he said he wanted to plead guilty. He was asked if anyone was making him plead guilty, and he said no. These declarations, as this court has held numerous times, carry a strong presumption of truth, and the petitioner in this case has not overcome that presumption. In fact, the Blankenship factors govern review of this question and strongly support that presumption. The first factor, there's no evidence that petitioner did not have a relative intelligence to understand his plea, and in fact, at the plea hearing, he testified that yes, he did have a prior criminal history, so he understood criminal proceedings and the plea process. He was represented by competent counsel who was able to negotiate a 20-year plea and avoid a possible life sentence. He was able to confer with his counsel, although he testified at the plea hearing that I think he said maybe he never met him in jail and only met him a few times at the court proceedings. Trial counsel testified that he met and discussed discovery and went over the case, all of the 10 court dates, and the PC court has found that to be credible. And the plea hearing as well, at the plea hearing, the trial court reviewed the petitioner's charges and potential punishment. But finally, and most significantly, the final Blankenship factor, which is the reason that the petitioner pled guilty, testimony from both the trial counsel and the petitioner established that the petitioner pled guilty out of a strong desire to avoid greater penalty. Counsel testified at the PC hearing that it was the state's reduction of the plea offer. The state reduced it at least 2 times. So it was the reduction of the plea offer to 20 years combined with petitioner's fear as to what his exposure was. And the last straw was confirmation that the state had in its possession the petitioner's cell phone that was found at Ms. Bass's apartment complex. Even at the PC hearing, the petitioner himself said that he recognized that he might get life and that 18, I think he meant 20, sounded way better than a life sentence. He didn't feel comfortable.
1 minute left, General.
1 minute, sir? 1 minute. 1 minute, thank you. The Blankenship factors certainly support that the plea was voluntary. Defense counsel argues that it wasn't voluntary because he didn't feel that his counsel was making any effort for him. That's just the trial court, the PC court made specific findings that contradict that. All the things that trial counsel did on behalf of the petitioner, his claim, and this court, as recently as Saturday, in a case that where Judge Dyer was on the panel, rejected such a claim that's why I pled guilty, because I felt that my counsel wasn't putting in every effort. You look at the colloquy and the Blankenship factors, and And that's what drives this court's decision, and not an incredible claim that his counsel wasn't putting in any effort for him. So unless there are any questions, I will ask this court to affirm the judgment of the PC court.
All right, thank you. Rebuttal?
Oh, yes, Your Honor, very briefly. As far as the questions about whether I'm attacking the whole plea, I did put in my amended petition, I made a very concerted effort to list all of those indictment numbers. So I remember thinking at the time I filed that amended petition, my intent definitely was to attack, set aside all of the convictions. That's why I put all those numbers in there. As far as whether a person's height is important in a Biggers analysis, I would respectfully submit that it is, because if you have AB saying the perpetrator was 5'11" to 6 feet, and LH saying the victim was tall, the defendant was tall, and then Mr. Morgan, the petitioner, is 5'6", that indicates that the victims may have the wrong person, and that goes directly toward identity if you're talking about a whole different person. So height is definitely an important factor, I would respectfully submit. As far as getting the medical records, the state argues that that's a fishing expedition, that counsel had no reason to think the victim was intoxicated. I respectfully submit that that's just part of due diligence as a defense attorney, to try to get those records and, investigate to see what's in there, see if there's anything helpful. It might be fishing a little bit, but I think you have a duty, it's to a certain degree, to look at those records, to leave no stone unturned, especially in a very serious case like this one. And I would just submit it on the knowing, intelligent, voluntary guilty plea. The petitioner was very clear that he said that he felt counsel just wasn't fighting for him. He didn't want to go to trial with counsel. He felt that counsel was kind of rushing him on the day of the plea. And so I would just ask the court to reverse the post-conviction court. Thank you again.
All right, thank you. Well, that concludes the argument in this case, and the court thanks both counsel for presenting the argument today.
Thank you, Your Honor.
Thank you, Your Honor.
This court is now in recess.